following news flash is brought to you by the Lone Star Lowdown, providing your daily bulletins for the commodities market. Today in history, news updates, and the inside scoop into the tides of the alternative. Markets for Wednesday, March 9th, 2016 are currently trading with gold at $1,252.65 an ounce, silver $15.29 an ounce, Texas crude $36.50 a barrel, and Bitcoin is currently sitting about 411 U.S. currency. Today in history, the year 1961, the first animal safely returned from space after completing one full orbit around the Earth in Sputnik 9. A doggy named Chernushka, or Blackie, returned from the heavens. Today in history. In recent news, Tayrod Pugh, a U.S. Air Force veteran, was found guilty today of attempting to join the Islamic State. After a week-long trial at a Brooklyn federal court, a jury found Tayrod guilty of attempting to provide material support to ISIS and guilty of obstruction for destroying 4 e-storage drives after his detention in Turkey. Pugh is set to be sentenced in September. Pugh's defense lawyer is arguing that all he did was express repugnant views about the Islamic State on Facebook and watch dozens of the group's recruitment videos, and that he was only traveling to Turkey to find work, not to become a jihadist. However, prosecutors are presenting a letter he apparently drafted to his Egyptian wife, which was found on his laptop, in which he vowed to fight for Islam. When detained in Istanbul, he apparently had a black face mask, a map depicting Islamic State's strongholds in Syria, and a chart of the border crossings between Turkey and Syria. Pugh served as an avionics specialist in the Air Force from 1986 to 1990, and later worked as an Army contractor in Iraq from 2009 to 2010. Toyota recently showed off a new device that could dramatically assist the visually impaired to better navigate their surroundings. Called Project Blade, an informational device to bridge the gap between a cane or a guide dog, Toyota has been testing various prototypes of the wearable device with individuals from the visually impaired community for the past 3 years, and though the details of the project were released this week, no official timeline has been set for the release. The automaker plans incorporating mapping, object identification, and facial mapping technologies into Blade in the future. Doug Moore, manager of Partner Robotics at Toyota, told ABC that Toyota is thinking about quality of life for individuals and how to impact society. The Lone Star Lowdown is currently looking to fill some ad space. If you have a product or service you'd like to advertise with us, feel free to give me a call at 210-363-2257. This is Rick Brody with your Lowdown for March 9th, 2016.
Okay, we are back. Randy Kelton, Real Law Radio, and apologize for the issues that we were having. I think we have everything sorted out. Those last 2 segments were the last time Ron Avery was on. We have Ron Avery here with us now. Everything's up and working right. And we're going to go to Ron in a moment, but first I want to finish up with Jim. And Jim, once I finish this challenge subject matter jurisdiction, then I'm going to go to Ron, and we'll probably spend an hour to hour and a half, and then call back in, and we can go back to what you're doing. We have 2 more callers. Scott and Alex, I appreciate you guys holding on, but if you will drop off, and as soon as we finish with Ron Avery, we'll reopen the phone lines just so you don't have to hang on the phone this whole time, and then we'll go back to the phones. Okay, we were finishing up this statute on who can apply to the Department of Public Safety to be certified to enforce the Transportation Code. And if you've never heard this before, it's kind of remarkable. The last one we read was a municipality with a population of less than 8,500 that is the county seat and contains a highway that is part of the National System of Air and Defense Highways. So now we go to the next section is a sheriff or deputy sheriff in a county bordering the United Mexican States or of a county with a population of 1 million or more is eligible to apply for certification under this section. A sheriff, a deputy sheriff, or any peace officer that does not attend continuing education courses on the enforcement of traffic and highway laws, on the use of radar equipment as prescribed by Subchapter F, Chapter 1701, Occupations Code, shall not enforce traffic and highway laws. The department by rule shall establish reasonable fees sufficient to cover from a municipality or a county. The Department of The department by rule shall establish reasonable fees sufficient to recover from a municipality or a county the cost of certifying its peace officers under this section. Now, these are the municipalities that can apply for certification for one of its officers. Now let's go down and see how this actually works. Enforcement of the Texas Transportation Code is limited by 701.001 as follows. Except as provided by subsection C, acting in conjunction with the sheriff of the county, the commissioner's court of a county may employ not more than 5 regular deputies as county traffic officers. Except as provided by subsection C, the commissioner's court may employ not more than 2 additional deputies as county traffic officers to aid the regular traffic officers in special emergencies. The limitation on the number of deputies that may be employed under subsection A and B does not apply to a county with a population more than 2 million. Now, here in the Dallas-Fort Worth area, I can't find anybody that fits that description. Okay, and I'm not going to go into 643, the rest of the Transportation Code. This is just a list of those areas and officers. You get the part where it said they can only appoint 5 officers? And those 5 officers must fall within the limits set for municipalities authorizing those officers or for a sheriff's department. Sheriff's department can have 5. Now, those 5 can all be municipal officers, apparently, if they want them to. But they only got 5 to enforce it. Reckon how many we have in Dallas-Fort Worth area enforcing the traffic laws. And I wonder how many of those are participating in this continuing education as required by statute. So my question to you, Jim, is, seems I lost my call board. Okay. I'm not sure what's going on here and why we don't have any callers. Anyway, I was finishing up with Jim. Jim, if you can hear me, call back when we finish with Mr. Avery. And I will go back through this again. I think this is real important for anyone who is going to take on the right to travel issue. The first place the officer must go is jurisdiction. We don't just presume jurisdiction. Well, they do if you don't challenge it. So if you're going to take on the traffic issue, the very first thing to ask of the court is that the court show that the officer who purported to enforce the traffic code fell within these requirements. Otherwise, nothing the purported traffic officer says is of any value because he has no authority to enforce. Okay, that's enough of that. We'll pick this up when we finish with Ron. If we have time today, we've already used up an hour, so we're going to want to give Mr. Avery all the time he wants to address his issue because I think this is really important to all of us. Okay, let's go to Mr. Ron Avery. Hello, Ron.
Hey, Randy.
I understand you went to court recently on your libel suit, and the court dismissed.
Yes. The defendants filed a motion to dismiss under the Texas Citizen Participation Act, and they, of course, they filed the big motion, and I responded to it, and then they finally held the hearing on it, and the judge took it under advisement. He didn't rule on it that day, but which I, in fact, asked him to do, would take it under advisement to study all the documents, which was quite considerable already. And the result was he came back and granted the motion. And so if I'm going to keep these guys in court, I've got to appeal it.
Okay. When he granted the motion, did he provide findings of fact and conclusions of law?
No, that's really a separate thing. They normally don't do that at the same time. Usually a party has to request that if they're going up on appeal.
Yeah, well, this one has an expedited appeal process.
That's correct.
Is there a provision to request findings of fact? Because there's no way for you to.
No, yeah, I know what you're saying. That so much material. It's better to go up on appeal when a judge has made his findings based on a particular thing instead of a whole bucket of stuff containing everything in the world that's been filed. So, but in every case, you have a right to request findings of fact and conclusions of law. And in this case, however, under an accelerated appeal, they don't give you time for the judge to actually answer it. In other words, normally the judge has about 30 days to do this and file it. In this case, and normally after he files that, or either he denies your request, which he can do too, if he wants to, just deny that, then your clock starts running from your appeal clock. Notice of appeal clock runs from the time that he denies that request or he files his answer to it. So in this case, though, filing a request for findings of fact and conclusions of law do not extend the time in which you can file your notice of appeal. So I have 20 days from the date the order was signed to file a notice of appeal, regardless of whether he answers or denies or does anything with a request for findings of fact. Mm-hmm.
Okay, hold on. Your notice of appeal, generally a notice of appeal is I hereby give notice of my intent to appeal. In this expedited case, do you have to file your appeal within 20 days?
Oh, no. What that does is your notice tells them that the court should begin to put the record together to send to the appellate court. And in this case, under the accelerated appeal, the court only has 10 days to file the record at the appellate court.
Well, at the same time you file the notice of appeal, you might consider filing a request for findings of fact and conclusions of law, because in the end you're going to need that.
Well, it'd be helpful. That doesn't mean they're going to do it, but...
no, here's the issue. If they've passed this statute and they're using this statute to make it so that these large newspaper or news agencies can libel people essentially at will and accelerate these processes, so now you have to appeal something and you have no idea what you're appealing.
Well, yeah, because you have to appeal. I think that's not totally true, because what you have is the motion to dismiss is under a special act, a special legislative act, and that act has certain requirements. And if you can show that the other side did not meet those requirements and should not have had their motion granted, then that's what you need to show.
Okay, so you're only appealing this is an interlocutory appeal on the motion to dismiss.
Well, it's really not an interlocutory appeal, because that would apply to the defendant, because the defendant would still be in court.
I'm sorry, you're right. This is not an interlocutory appeal, because
in my case, since they granted the motion, it's being kicked out of court. So okay.
It's a dispositive motion.
But they still allow you for an accelerated appeal, but it's not interlocutory. It doesn't stop the court from doing anything, or it doesn't continue. The court doesn't continue while you're doing that. The lower court.
I'm just looking at how this new statute can be used by the large news firms to make it harder for you to fight them.
Yeah, and I'll tell you really where I think the main problem is they give a definition in the act which is inaccurate. The first step of 3 that must be proven under this act is that it must be proven that the person that files the motion to dismiss was actually exercising their constitutional petition and association. And that could be kind of difficult for some people in certain kinds of lawsuits. But under a libel suit against a media company, all they have to say to pass step 1 is, we wrote an article and this guy sued us for it. And that's all they have to say. Now, let me tell you what the real problem with that is. In news reporting, a reporter is ethically forbidden to participate in the event he is covering in order to maintain his objectivity. And he is also forbidden to write his own opinion in the coverage of that news event. So in reality, any newsman cannot legitimately use this act to get, or shouldn't be able to use this act to get a dismissal, because the news people are not exercising their own right of free speech, association, and petitioning. They are simply reporting on others doing that.
So the newsman could state what I claim is my opinion, but he couldn't state his own opinion.
Well, this is how it's, well, that's right. Now, the other thing is, that doesn't mean a news person could not violate the general ethic, and some of them do it, but here's what they have to do. They have to participate in the event, and then when they write an article on it, they also have to notify the reader that they are now giving their opinion rather than statements of fact. And if they are doing that in the article, then they can use this act, because they have shifted from someone just reporting on others to one who is actually exercising their own liberties.
And in that context, it would seem perfectly reasonable.
That's right. And I pointed this out, too, in my pleadings, is that there is no evidence on record that Badower claimed he was doing any of that. He's the reporter that I sued. And there's he didn't say in any affidavit or any of his pleadings that he was actually at the meeting participating, or that he gave any of his own opinions in the article he wrote. They're claiming everything he said was factual. And, well, I mean, right there, if it's all factual and you just went to the meeting and observed it and you simply reported on it, well, you never participated. You never became a participant to exercise your own rights.
So in order to be protected, you have to be an observer and state facts, or let people know that you're not a neutral observer.
Well, what it really means
you're an engaged participant.
It is for anybody that wants to use this act has to prove that they weren't a newsman in the bubble of objectivity that's merely reporting on others. They have to say, my personal opinion about this is that, and I saw these guys, but I think they are just a bunch of this or that, and that I participated in it. I held up my hand and I was waving a sign, and here I am. Here's an example of me participating. Well, there you go. Here's a guy that's actually exercising their constitutional rights, and he can use this act to get out of a suit that he's been sued for actually exercising those rights. But a newsman that never breaks the bubble of objectivity, where he does not participate and never gives his own opinion, he can't use the act. He should, or at least he shouldn't be able to use the act, because he's not exercising his rights. He is simply reporting on others doing it.
Now, wait a minute. If he is sued for libel, then he doesn't need to use this act to defend the libel suit if he's reported fact and not opinion. And the fact that he reported was accurate, he can use the accuracy of the fact to defend his position. So,
well, he can always defend his position. And this act doesn't prevent anybody from defending themselves from a libel suit. What this act does is it gives special provisions for those who are sued when they were actually exercising their constitutional rights. But as I said before, how can a newsman that's acting objectively and never participates and never gives his own opinion, how in the world can he prove that he can use the act? Unless he says in his affidavit or somewhere in the article it's obvious where he says, I attended this meeting and I held up a sign that said, go Trump, go. And I love Trump. And then at some place in the article he says, I think Trump is the best candidate ever because I love his hair. Well, in this case, if he gets sued for writing that, he can use this act to get a quick dismissal of it if they really don't have a libel suit. But a guy that just goes to a rally for Trump, doesn't hold up a sign, and in his article he just says there were lots of people at the meeting and they all jumping up and down and yelling "Hooray, Trump!" and and somebody got mad and didn't like it. All he's doing is reporting facts, and he never got involved in any of it. So he's not exercising any constitutional rights whatsoever. He is just reporting on others doing it.
So I'm trying to understand specifically what this legislation was intended to do. It appears as though. Go ahead.
It tells you right in the act. It says, well, let me go get it really quick, because I'll just read it to you because it's pretty clear. Let's see.
While you're getting that, it sounds like there. Okay, go ahead.
Okay, I think I got it right here. Server. Somehow my server is not working.
Okay, while you're getting that, it sounds like it was intended to protect someone other than your standard professional newscaster, because they've already got a whole stack of protections anyway. We had a friend of ours who was politically active, trying to get rid of what they considered a really corrupt family court judge. And she got one of these suits from two attorneys that were being appointed by this judge as ad litem attorneys. So they were making a lot of money from this judge. And they sued her to stop her from campaigning against this judge. And she took that to the courts, and the courts threw their suit out and sanctioned the lawyers for filing it. Yeah. But she wasn't a news agency. She was an ordinary person exercising their own personal rights.
There you go. And that's what I couldn't get it online, but I have the book right here, so I just pulled it up. And it says right here that the purpose of this chapter is to encourage and safeguard the constitutional rights of persons to petition, speak freely, associate freely, and otherwise participate in government to the maximum extent permitted by law, and at the same time protect the rights of a person to file meritorious lawsuits for demonstrable injury. So it is really to give a quick release if there's there's some libel cases that really don't have much merit to it. Is what it, and there are some of those, and I can see that. And you know how people are; they're very litigious, and they could sue you and keep you in trial for 7 or 8 years on a piece of junk to start with. I know I've seen that and been involved in that myself.
This case I spoke to, the primary was coming up, and they filed this to stop her from electioneering against this judge before the primary came up. So it was very time sensitive. It was exactly dead on what it appears this legislation was intended to protect. And by the way, the judge lost his primary.
Yeah, I think you're right. I think that's why the legislature overwhelmingly approved this legislation. Not overwhelmingly, it was a unanimous decision to pass this legislation, this act. And I think it's because all these guys run for office, and they're all afraid of saying something during the election and being sued and then hung up in court during their campaign or whatever for years or too long, and all the expense of it. So they all were in favor of this act. But the real.
Do you sleep with your cell phone? If the answer is yes, you might be among a growing number of folks who suffer from nomophobia. I'm Dr. Catherine Albrecht, and I'll tell you about people's growing fear of being disconnected next.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Do you take your cell phone into the bathroom or panic if it's not in arm's reach? Do you keep an extra phone on hand just in case your main phone stops working? If you do any of these things, you may have nomophobia or no mobile phobia, the fear of being caught without your cell phone. And you wouldn't be alone. A recent survey finds 2/3 of us feel afraid without our cell phones. That's a huge increase over just 4 years ago. And the problem is even worse among young people, where nearly 8 out of 10 people under 24 feel anxious when they're unplugged. How could a technology that's supposed to simplify our lives have become such a burden? I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
We'll be kidding about chemtrails.
Looking for some truth? You found it. LogosRadioNetwork.com.
Okay, we are back. Randy Kelton, Rules Law Radio, and I kind of let us run off the cliff there. That was my fault. And I'm going to have to take the blame because my producer wouldn't let me push the blame off on him. So, we were talking about who this legislation was intended to protect. And
Right.
that doesn't appear to be the news media. It appears the news media already has ample protection so long as they act within a set of well-established guidelines established by 200 years of case law.
That's actually pretty much true, I would say. I think you've got it right. And that the real group that is to protect is citizens who are out in the process of trying to involve themselves in participating in government and political matters or big public matters that have to do with the community and community well-being, and from suits that are aimed at them just to shut them up, that kind of thing.
And yeah, that was the one I spoke to earlier was absolutely classic for
Yes.
what it was intended. And here we have, the question I was bringing earlier about how the judge actually ruled. Since you haven't gotten through the discovery or to the actual argument of the issues in the case, he would have to rule based on your original pleading.
That's right. It has to be.
Yeah.
I have to plead all. Well, as I said, this act has 3 steps to it. It's not just the first step. In order to initiate the act, the defendant has to prove that they were exercising their constitutional rights of free speech, petition, and association. If they can't prove that, which I don't think the defendants in my case could do, they without this stupid definition they have in the act, they could not continue the motion. That would the judge would just stop it right there and say, "Well, you weren't doing any of that, so you can't use this motion, this act. So you're out here. Motion denied."
Okay,
But-
let me see if I understand this right. We have a right to free speech, but do we have a right to operate a company that reports on events? If I get this right, Hearst Communications was operating a company for the purpose of commercially reporting on news events. Is that a constitutional right?
Well,
I'm saying no, it's not. You don't have a constitutional right to operate a business. I mean, that part's not in the Constitution.
well, I don't even think you have to go there. You don't have to get into the corporation or
No, I'm not.
all you have to do is say that the particular newsman, because the only reason I'm suing the corporation in the first place is because it is their employee who actually did the no-no, who actually libeled me, and so they're just kind of a vicarious connection that.
Wait, no, I'm not. I don't go to this corporate stuff. That's not where I was going. This person at this time was reporting news. He wasn't exercising his right to free speech. He was just reporting news.
Correct.
So this wasn't intended to protect him while he's reporting news. Now,
That's
if
right.
he includes in that news his own opinion, then this would have protected him.
Correct.
He didn't do that. He reported supposed facts that were false.
Correct.
And all of the 200 years of case law on libel says that makes him liable for his actions. And if this legislation is interpreted to protect the newsman and convert reporting news into exercising a right, then that dramatically changes the limits of the constitutional right. That's going to change 200.
I agree. And here's another thing that I think that this legislation does. I don't know if we mentioned it last Friday on the show or not, but the idea that the legislature can tell the judiciary how to try cases by passing legislation to me, is a violation of the Texas Constitution, Article 2, Section 1, which says the government shall be broken into 3 departments, and no one or more members of one can have any power at all whatsoever to do with the other. So the idea that the Texas legislature can pass legislation over there in their department that tells the judiciary next door over there in their department how to rule and judge on cases that are tried in their court seems to be a violation of the Texas Constitution, just right up front. Now, they shouldn't have authority to tell the judiciary what is libel and when it is and who it occurs and what the definition of free speech is. That's the job of the judiciary. That's the job of the courts, not the job of a bunch of guys sitting around wanting to know how to get out of lawsuits when they're running for office.
Okay, this goes right to the Speedy Trial Act. The legislature passed 3202A, Texas Code of Criminal Procedure, and it said that if you don't try a Class C misdemeanor within 90 days, that the court will enter a ruling of not guilty. And the court said, you can't do that. You cannot legislate a court ruling.
Yeah.
Now, if they had put in the statute, if you do not try a person within 90 days, the presumption is that the delay was unreasonable and the defendant shall have a right to dismissal. That would establish the right, which they can do, and would not have dictated and would have given the court some leeway to determine if the time limit was justified. Like the defendant asked for a continuance. That wouldn't toll the time limits. So the legislature, by dictating a ruling, violated the Constitution. That's a good case for your issue. I'm kind of even
amazed because speaking of that very time of trials, the Supreme Court of Texas is the one that determines the timeline for when cases should be disposed. And for civil trials without a jury, it's 1 year. And for civil trials with a jury, it's 18 months. And that's set by the Supreme Court, not by the legislature over there just saying, you need to step these things up and move them along, So I still, to me, I think this whole act is kind of a violation of the Constitution.
Yeah. The point of that one was that's dead on your issue here.
Yeah.
If the court treats this legislation as if it directs them to render a specific ruling.
Yes. Well, that's a good one.
In the matter of 3202A, that's already been addressed where the legislature, where the court said the legislature has no power to do that. So if the court doesn't treat it that way, then they'll have to rule in your favor.
Yeah. I also see that that when they make a definition over here in 27.0013, it says exercise of the right of free speech means a communication made in connection with a matter of public concern. Well, how much case law is in libel that talks about free speech? There's
easy.
Comments are lurking around the corner. You better watch every step you take. And good and good to follow you. Yeah, Billy Jerry. Sing reality. Okay, comments lurking around the corner.
Okay, we are back. We fell off the cliff, but we both recovered. I apologize for that. I got so engaged in the conversation that I didn't watch my clock again. Okay. And we were talking about...
Say, how much time do we have? Maybe I could even help you. 10 minutes? Are we on for 10 minutes?
No, I have a clock here in front of me. I just need to look at it. Each segment is somewhat of a different time.
Right, okay.
This is showing me I've got 11:46. Okay, Ron, when we went off, we were talking about I lost it. The legislature trying to dictate. I'm sorry, that's what we got past that to the the overbroad general nature of the wording of this definition. I think you said in section 27.
I was just saying that how the legislature could define the exercise of the right of free speech to mean a communication made in connection with a matter of public concern. So they have specified exactly what the right of free speech is for the purpose of this act. And it actually it gives the media a free ride. They don't have to prove anything. All they have to say is, we wrote an article and we got sued for it. And so they can use the act. So everything they write and get sued for, they can now use this act. And they don't have to prove that, well, in one case, where they ought to still have to prove that they were exercising their own right of free speech and association and petition, because some news people do. And I want to redirect our audience to my website, where I have a beautiful example of this, that they can actually go hear a video and watch a video of it's O'Reilly on the Fox News, or the what they call it, the Factor, and he has a guest who is the owner of Univision, and his name is Jorge Ramos, and they are talking about the Trump campaign, and O'Reilly tells Ramos that since he has come out with a book and he has said that he thinks Trump is a racist, that he can no longer, his whole TV station can no longer objectively cover the Trump campaign for president. And why? Because he broke the objectivity bubble. He has become a participant. He is exercising his own liberties and rights to give his own opinion about things, which is his right to do. He had a right to do that. But now he has to tell his viewers, and this is what even O'Reilly told him. He said, you're going to have to put a tag down at the bottom of your news channel every time you do a story on Trump that says Univision thinks he's a racist, and leave that on there, and that becomes your exercise of your own freedom of speech. And if you get sued for it, see, he could actually use this act now because he has ceased to be in the bubble of objectivity by not participating in any event in the campaign. He has ceased to be objective about refraining from putting his own opinions in articles. He's broken the bubble of objectivity. He's beginning to participate. He's making a statement, carrying a sign that Trump is a racist, and therefore, if he ever got sued for this, he could use this act and legitimately, because he's just now another citizen exercising his rights. But it's just if he had never done this, if he had only reported on facts about Trump and his campaign, and somebody sued him, he can't use the act because he'd have to, without proof that he was actually exercising his own rights, he can't come up to he can't pass the first step of this act, except for the very fact that in the act it has this very stupid definition of free speech, which gives a free pass to every news journalist alive. They can print anything however they want, whether it be fact or truth or opinion or statements of fact or whatever, and use this act to dance out of it.
This is a perfect case to define the legislation. Since
I think so too.
This act was passed unanimously, it sounds like the legislature made a major blunder here.
I think it could be corrected. I don't know that they have to throw the whole act out, but it certainly needs to be altered and amended, because this stupid definition gives a free pass to the news media no matter what they do. They can file this every time.
It sounds like it will have the opposite effect of what was intended by the act.
Well, I guess so. I mean, and see what this actually does. When this judge actually granted this motion, it told the world that I filed a SLAPP suit, which is a strategic lawsuit against public participation. Well, now, I just tell everybody right now, God knows I did not do that. This is not a slap suit. I did not file anything to prevent Bad Hour or Hearst Communications from saying anything they wanted to, from exercising any constitutional right they wanted to. They could call me whatever they want to, but it would have to be their own opinion, their own right, and all of that stuff. And of course, this suit wasn't filed to shut them up and to prevent their participation. It was to prevent them from telling lies about me and creating a terrorist from an ordinary citizen and in their newspaper. And that's what it's about. And I'm the only guy that has any evidence in this case of participating in a public event, a public issue, is me. I was the one that went and spoke before a group. I was associating with this group, even though I wasn't a member of it. And I spoke before it, exercising my freedom of speech. And what happened? They wrote a story and published this story that made me look like a terrorist. And in fact, people said in the blog under the article they wrote online that I was indeed just like Muslim terrorists, and I needed to be rounded up, sent to Gitmo, and waterboarded. And I don't think the newspaper ought to be able to get away with stuff like that.
What I was thinking is, have you talked to any of the legislators who voted for this legislation?
I don't have time to do that, Randy. I can barely keep my head. I can barely keep this case going, much less run around and do stuff like that. I mean, you're talking about somebody that's got means and capital and time, and that's not me.
Well, hold on. One of the things that in doing this show and doing what I do with going after government officials and such, is it became clear that you'll never win your case simply because you have the law and the facts on your side. You'll only win your case if you have the politics on your side. Well, and what I see here
there's a lot of truth.
Is I see some major politics here. I would suggest that if you made a call to your local state representative and said, look what the court is doing with this slap suit legislation that you put in place to protect yourselves from improper news coverage that would jeopardize your ability to effectively run for office. And because of the way the court is looking to interpret this definition, it's going to cause this legislation to have absolutely the opposite effect. Yeah. So that these newspapers can call you anything they want to, and they are absolutely immune. You guys might want to call Hearst Communications because they have the politics.
Well, that might work. I mean, I think that might be a good idea.
Yeah, and I suspect you tell one, and he's going to get on the horn to everybody else in the party. I suspect this is something that'll terrify both parties.
Oh, I would think both parties would be interested in that. And since it was passed unanimously, both parties obviously were in favor of it and saw the purpose was good, at least.
Yeah, you might find Hearst Communications coming to you and say, hey, let's have a little talk here.
Yeah, that'll be the day. That's optimistic. I like that, and I appreciate that. But I'll wait till I see that.
Well, everything's political, and it took me a long time to get my head wrapped around that.
Oh yeah, I had a friend in college that got a master's at the University of Houston in political science, and then got a scholarship to Berkeley. And he told me, and he would tell everyone that everything is political. That's what everything.
Okay, hang on. This time we're not going to fall off the cliff. This is Randy Kelton, Rule of Law Radio. Our call-in number 512-646-1984. We will probably open the phone lines after this next segment. We'll dedicate 2 more segments to this, but in the next segment we'll open the phone lines so people can call in and be in line when we get to the phones. We'll be right back.